You started your business, you picked the perfect name, you built the brand, and now someone is telling you, protect your intellectual property. So you Google it, and now you're more confused when you started because no one online is explaining the difference between a copyright and a trademark in a way that actually makes sense for where you are right now. So today I'm gonna fix that. I'm a business and trademark attorney, and I created an entire legal template suite specifically for content creators and entrepreneurs because this information should not be that hard to access. I'm breaking down the 5 things you need to understand about trademark versus copyright so you can stop guessing and start protecting. If you're building a brand and you don't know which one you need, listen closely. Number 1, trademark and copyright protect completely different things, and mixing them up is costing entrepreneurs real money. Here's the simplest way I can put it. Trademark protects your brand identity, copyright protects your creative work. That's it, 2 different lanes. Trademark covers your business name, your logo, your slogan, the name of your signature program or offer. It protects the things that make your brand recognizable, the identifiers people associate with you. Copyright covers your ebooks, your course content, your website copy, your podcast episodes, your social media posts, your videos. It protects the work you create. Now here's where people get this wrong. I'll see entrepreneurs rushing to copyright their logo, spending time and money registering a creative work, when actually a logo is better protected by a trademark. And I see entrepreneurs building entire brands, running ads, pitching to partners, growing audiences under a name that they haven't legally secured. These are not small mistakes, these are expensive ones. So before we go any further, get clear on this distinction because everything else builds on it. Number 2, copyright attaches automatically, trademark doesn't. This is one of the most important things that I preach, and it genuinely surprises a lot of people. The moment you write your ebook, record your podcast, create that course content, copyright automatically exists. You don't have to register it. You don't have to file anything. The moment original work is created in a tangible fixed form, the copyright is yours. So why does registration matter? Because if someone else steals your content, copies your course, lifts your copy, reproduces your material, registration through the U.S. Copyright Office gives you the ability to sue in federal court and get significant damages. Without registration, your enforcement options are limited. So copyright registration isn't about creating the right, it's about being able to enforce it. Now, trademark is completely different. There is no automatic trademark protection. You can use a name in business for 5 years and still have 0 federal trademark rights if you never filed. Someone can file a trademark name similar to yours, and even if you were the first to use it, now they have the federal registration. And now you have a legal fight that's gonna cost you significantly more than if you would have just filed in the first place. This is not theoretical or hypothetical. This happens constantly with entrepreneurs who are building in public, gaining visibility, and assuming that using the name means they own it. Using it is not the same as owning it. Number 3, your LLC does not protect your brand name. And I have to say this clearly because I feel like it's one of the most common misconceptions that I encounter. I get this question constantly, but I have an LLC. Doesn't that protect my name? No. Your LLC protects your personal liability. That means if your business gets sued, your personal assets like your car, your home, your savings, they're all generally protected. That is important and you need that protection. But your LLC does not give you exclusive rights to your business name. It doesn't stop someone in another state from forming a business with a name that's nearly identical to yours. It doesn't give you the ability to stop copycats or send cease and desist letters based off of brand name infringement. That is trademark territory. Think about it this way. Your LLC is the legal structure of your business, and your trademark is the legal ownership of the brand name that's within that business. You need both, but they're doing completely different jobs. So if you have an LLC and no trademark, you have liability protection, but your brand name is still unprotected. Anyone can use something confusingly similar, and you would have very little recourse. File both, understand what each one does, and don't let one give you false confidence about the other. Number 4, the most expensive mistake I see most entrepreneurs make is protecting the product before protecting the brand. Let me show you how this plays out. You create a course. Maybe it makes you $15,000. You register the copyright. Smart. You write an ebook. Maybe it makes you $3,000. You register the copyright. Smart. But your brand name, the name on your social media handles, the name on your website, your domain, your marketing materials, the name that people are starting to associate with you, unprotected. Here's the truth about what most legal content online doesn't say clearly enough. Your ebook can be rewritten and your course can be recreated. Your brand name, the one your audience knows, the one attached to your SEO, your domain, years of content, your reputation cannot easily be replaced. If someone forces you to rebrand because they filed a trademark for your name before you did, here's what you actually lose. Every dollar you spent on SEO, gone. Your domain and all the traffic attached to it, your social media handles, your audience recognition, every single marketing dollar spent driving people towards that name. I have seen creators and entrepreneurs wait until they blew up to file. We see it all the time again, we literally just saw it with Mr. Tendernism. If you know, you know. By the time you're ready to file, someone else has already beat you to it. The name you built your entire brand around will no longer be available. A rebrand is going to cost you more financially, emotionally, and in momentum when you can spend a fraction of the cost by just filing a trademark to begin with. Do not let that be your story. The best time to file is before you have the audience, because by the time you're viral, that's when the copycats like to show up. And by then, filing is reactive, and reactive is always more expensive than proactive. Number 5, this is not about copyright versus trademark forever. It's about sequencing. Getting the sequence right is what separates the entrepreneurs who are building protected brands from those who are constantly putting out fires. Here's how I think about the sequence for most entrepreneurs. For most service providers, coaches, consultants, course creators, online brand builders, trademark first. Your name is the foundation. Everything is built on top of it. So if the foundation is vulnerable, everything above it is vulnerable too. Step 1 is a proper trademark search. Not a Google search, not a social media handle check, a real comprehensive check of the USPTO's database. You need to know whether your name is legally available and whether there's any conflicts you need to be aware about. Number 2 is confirming that your name is even protectable. The USPTO has specific requirements. Names that are too generic or too descriptive or too close to existing marks face significant obstacles. This is exactly why the filing process matters and why going in without guidance can cost you more than doing it right the first time. Step 3 is filing strategically in the right class of goods and services for your business. Filing in the wrong class creates gaps in your protection, and filing in unnecessary classes wastes money. Strategy matters here more than speed. Now, if you're an author publishing or distributing a book at scale, or a creative whose revenue depends specifically on one creative work, copyright registration may be your higher priority. And if your name or your pen name is your brand, trademark that too. For the majority of women building brands online, trademark first. At scale. And I want you to think at scale, even if you're not there yet, you'll need both. Trademark to protect your brand and copyright registration on your most valuable creative assets. Contracts governing how your content is used, how your collaborations work, how your partnerships are structured, business entity formation for liability protection. This is layered legal infrastructure, not panic purchases when something goes wrong. The entrepreneurs that are building generational wealth are not just building revenue. They're building something with legal protection underneath it so it can be valued, licensed, scaled, and passed on. That starts with getting the sequence right. Let me make this as practical as possible. You just launched your coaching or consulting brand. Start with a trademark search on your business name. Protect the foundation before you build any higher. Created a digital product, a template, a guide, a mini course. Your copyright exists automatically. Focus on brand protection before spending any money on copyright registration for a product. And make sure that the contracts governing how this product is sold and used is airtight before you launch. Publishing a book that you plan to distribute at scale. Copyright registration moves up the priority list. And if your name or your author brand is a business, trademark it. Scaling, licensing content, entering brand partnerships. You need both trademark and copyright registration and airtight contracts on every deal. Here's what I want you to take from all this. Trademarks protect your identity, copyrights protect your creativity, and your LLC protects your liability. And none of them do the other's job. Get clear on what each one does, get the sequence right, and stop waiting until you're big enough to protect what you're building, because by then you're already behind. Too many talented women, especially women of color, have lost brand names, creative rights, and business assets they worked incredibly hard to build, simply because nobody gave them this information early enough. You now have it, so use it. If this gave you clarity, subscribe, because each week we're going deeper on trademarks, copyrights, contracts, and the legal strategy that serious entrepreneurs actually need. And if you're ready to stop guessing and start protecting your brand the right way, I put together attorney-drafted legal templates and a full legal starter guide specifically for entrepreneurs and creators like you. Everything you need to get your legal foundation in place without the overwhelm. Links are in the description. Protect your work and own your future. I'll see you guys in the next video.